Skogen v. Dow Chemical Company. 375 F.2d 692, 8th Sir 1967. Before Van Oosterhout, Gibson and Heaney, Circuit Judges. Gibson, Circuit Judge, this is a product liability case concerning the use of an insecticide. Purina Spray and Dip. The product was manufactured by defendant Ralston Purina Company using Ronal, a chemical manufactured by defendant Dow Chemical Company. The jury, in answering a special interrogatory, found no causal connection between the exposure to the insecticide and the severe and permanent injuries suffered by the minor plaintiffs. The court entered judgment for defendants based upon the special interrogatory to the jury, and the plaintiffs filed a timely appeal. Plaintiff Harold Skogen was a farmer. He and his sons, plaintiffs Douglas and David Skogen, applied the insecticide Purina Spray and Dip in the course of their farm work. Both boys subsequently developed permanent brain damage. Plaintiffs sued defendants for their injuries. As noted by the experienced trial judge, the case presents essentially a factual issue on causation. This case was extensively and aggressively tried and defended during 17 trial days, with the jury being called upon to consider voluminous medical and scientific testimony. The medical testimony being directed toward the condition of the boys and their symptoms as either evidencing viral encephalitis, the defendant's theory, or organophosphate poisoning, the plaintiff's theory. P. Plaintiffs object to not being allowed to cross-examine two witnesses under Rule 43, b. Fed.R.Civilian.P. To begin, we must note the overwhelming nature of the evidence that supports the jury's verdict. Without going into the maze of technical data, the great weight of the evidence indicated that the chemical Ronal and Purina Spray and Dip were low in toxicity to humans, though it is an economic poison effective in killing flies and similar insects. Poisoning of the Skogen boys does not appear probable from a chemical of such low toxicity. Secondly, and more importantly, overexposure to chemicals causing organophosphate poisoning has definite symptoms. Viral encephalitis has definite symptoms which differ markedly from symptoms of organophosphate poisoning. The overwhelming weight of the medical evidence indicated that the Skogen boys had all of the symptoms of viral encephalitis, which symptoms would not be found in a case of organophosphate poisoning. The conclusion is inescapable that the evidence does not show the boys suffered from organophosphate poisoning as they alleged. The court reviewed the medical evidence in detail and concluded that the boys' symptoms were not consistent with organophosphate poisoning but were consistent with viral encephalitis, which can be contracted from farm animals. Admitting sufficiency of the evidence to support the jury's verdict, the plaintiffs contend that they should have a new trial because of alleged prejudicial errors which denied them a fair and impartial trial. We now examine their objections to the trial. Plaintiffs called as witnesses Bernard F. Beaver and Dr. Warren O. Haberman for the purpose of cross-examining these men under Rule 43, b. Fed.R.Civilian.P. Normally, a party conducts direct examination of witnesses it calls and cross. 14. Examination of the other side's witnesses. Leading questions are normally permitted only on cross-examination. However, at the time of this case, Rule 43, b. now Fed. R. Evid. 611, c. permitted a party to conduct cross-examination and therefore to ask leading questions when the party has called, as a witness, an adverse party, or an officer, director, or managing agent of a corporation, which is an adverse party. Beaver was a chemist in charge of the chemical formulation of Ralston Purina Spray and Dip. There were two or more persons who worked under Beaver's direction in the chemistry department. Dr. Haberman was the manager of the entomology and parasitomology laboratories of Ralston Purina. He had a staff of 3 or more individuals under him. After lengthy cross-examination, some 85 pages, of Beaver, at the suggestion of the trial court an objection was made on the basis that Beaver was not a proper adverse party being called for purposes of cross-examination, which objection, of course, was sustained. Dr. Haberman was called for cross-examination by plaintiffs. After a few questions the objection was made and sustained that he, too, was not a proper party for cross-examination under Rule 43b. Rule 43b authorizes the calling of an adverse party for cross-examination. In this situation, the calling party is free to ask leading questions and to impeach the testimony of his witness. However, a corporation, being an artificial entity, cannot be physically placed on the witness stand. To resolve this problem, the rule authorizes the calling of an officer, director, or managing agent as a representative of the adverse corporate party. Obviously, since Beaver and Dr. Haberman are not officers or directors, to be able to call these men and cross-examine them as adverse witnesses, it must be shown that they are managing agents of the defendant and not mere employees of the corporation. In this age of large corporate operations, it is often difficult to accurately classify individuals within a business into neat groups of managing agents and mere employees. The past few years have seen a mushrooming of corporations with highly technical and scientific departments. The individuals who head these departments are men of considerable education and extensive scientific knowledge and ability. Nonetheless, in a strict literal sense, these technicians and scientists are not general managing agents of the corporation. Yet it is probably unrealistic to classify these men along with the filing clerks, assembly line worker, and maintenance men as mere employees. We believe that this situation demands a liberal construction of the rules that takes into account the practicalities of the business world, the litigation which the business world must face, and the underlying rationale of the rule. The liberal interpretation of the rule which we favor would hold that an individual is a managing agent if 1. His interests in the litigation are identified with his principal, and 2. He acts with superior authority and general autonomy, being invested with broad powers to exercise his discretion with regard to the subject matter of the litigation. If this test were applied, we believe that Beaver and Dr. Haberman would probably be considered managing agents within the meaning of Rule 43b. It would seem that these two men were probably subject to call for cross-examination under the rule, and the trial court may have committed error in sustaining the objection that they were not managing agents of the adverse corporate party. Our tentative feeling on this point does not demand a reversal of this case. The rule is clear. 15. That harmless error by the trial court will not warrant a reversal of its judgment. An error is harmless if it is not inconsistent with substantial justice or does not affect the substantial rights of the parties. Rule 61, fed.r.civilian.p. We feel that any error of the trial court on this particular issue was harmless. Beaver was called for cross-examination by plaintiff and was in fact cross-examined without objection for a considerable length of time, 85 pages of record. Only after this substantial cross-examination was an objection made and sustained that he was not a proper party. We feel, as did the trial court, that by this time the witness was exhausted as a practical matter. Although plaintiffs had fully deposed the witness in pre-trial discovery proceedings, at no stage in the proceeding have plaintiffs shown, by offer of proof or otherwise, what additional testimony they expected to elicit from this witness or what real prejudice they suffered by not being allowed to cross-examine the witness further. At the time Beaver's testimony was interrupted, plaintiffs were apparently trying to prove through Beaver, Purina's negligence in testing and labeling the product. An issue that was not even reached by the jury as evidenced by the response to the special interrogator. Almost immediately, defendants objected to Dr. Haberman being called for cross-examination. However, after the objection was sustained, plaintiff's counsel questioned him at great length on a direct examination. No attempt was made to have him declared a hostile witness, so that leading questions might be asked. Later in the trial, Dr. Haberman was called by the defendant Ralston Purina in presenting their case in chief, and plaintiffs were then able to fully conduct a lengthy cross-examination of him. Therefore, it is difficult to see any possible prejudice to plaintiffs. As with Beaver, plaintiffs have demonstrated no additional evidence they hoped to receive, nor prejudice they have suffered from the trial court's limitation. When we view the vast amount of evidence that was received on this subject and how the great weight of it supports the finding of the jury, it further convinces us that the almost theoretical limitation on plaintiffs' examination of these two witnesses could not have deprived plaintiffs of any substantial rights, nor was the limitation inconsistent with substantial justice. 6 *****. Judgment is affirmed. 6 plaintiffs, in their brief, contend that Beaver and Dr. Haberman are at least hostile witnesses within the meaning of Rule 43(b). Hostile witnesses may be asked leading questions. This contention might be well taken as the witness's identity of interest is very close to their corporate employer. *****. The fact that defendant's counsel allowed Beaver to be cross-examined for some 85 pages indicates acceptance of the fact that Beaver was an unwilling or hostile witness for plaintiff's cause. However, at the trial, plaintiffs did not attempt to qualify either Beaver or Dr. Haberman as a hostile witness under the rule, and thus did not afford the trial judge an opportunity to rule on that point. It is elementary that we should not rule upon a point of law not presented to the trial judge. A trial judge ordinarily should not be charged with error in not deciding correctly a question that he was never asked to decide. We, however, feel this issue is not material, for, regardless of plaintiffs' failure to present the issue to the trial court, even if it had been presented and ruled adversely to them, no prejudice would have resulted for the same reasons set forth in our consideration of the managing agent issue. 16. Notes and questions. 1. The trial court ruled that Mr. Beaver and Dr. Haberman were not managing agents of the defendant corporation, and so the plaintiffs could not call them as witnesses for purposes of cross-examination. Was this wrong? If it was, why shouldn't the trial court's judgment be reversed? 2. The plaintiffs also complain that the trial court should have recognized that Mr. Beaver and Dr. Haberman were hostile witnesses, which would have been another ground for allowing plaintiffs to cross-examine them. See footnote 6 in the Court of Appeal's opinion. The Court of Appeals thought this was probably true, and yet this also was not ground for reversal. Why not? Note that the court gives two different reasons why this likely error could not lead to reversal. 3. Plaintiff sues defendant for breach of contract and the case goes to trial by jury. During jury selection, the plaintiff moves to strike juror X for cause, on the ground that during voir dire juror X demonstrated an unacceptable bias that would favor the defendant. The trial court denies this motion and juror X is seated. Juror X sits silently throughout the presentation of evidence. The trial lasts only a few hours and the jury is present in the court the entire time. At the close of evidence, juror X is taken ill and is excused from further service. The remaining jurors deliberate without juror X. The jury returns a verdict for the defendant, upon which judgment is entered. The plaintiff appeals. On appeal, the plaintiff argues that the trial court should have struck juror X for cause. The Court of Appeals agrees with the plaintiff on this point. What will the Court of Appeals do? 4. The scenario is the same as in the previous question, except that juror X is not taken ill and deliberates with the rest of the jury, and this time the jury returns a verdict for the plaintiff. The defendant appeals. On appeal, the defendant argues that the trial court should have struck juror X for cause. The Court of Appeals agrees with the defendant on this point. What will the Court of Appeals do? 5. Plaintiff sues defendant over a right-angle car accident and the key question is which party ran a red light when entering an intersection. During the trial, plaintiff testifies that she has no memory of the accident itself, but that a witness at the scene, who cannot now be located, told the plaintiff after the accident that the defendant ran a red light. The defendant makes no objection. The Jury returns a verdict for the plaintiff and defendant appeals. On appeal, the defendant argues that the plaintiff's testimony constituted inadmissible hearsay. The Court of Appeals agrees with the defendant on this point. What will the Court of Appeals do? 6. If a trial court commits error, why should its judgment not be reversed? Separately, consider the two reasons for not reversing illustrated by the case and questions above. What would happen if we did not have these two principles? Suppose a court of appeals were required to reverse a trial court's judgment if the Court of Appeals determined that the trial court made any error. What would be wrong with that? 17. The Pine Tar Case. Kansas City Royals v. New York Yankees. Decision of Lee MacPhail, President, American League. The 28th of July, 1983. With 2 out in the 9th inning of the game of the 24th of July, Kansas City at New York, George Brett hit a home run with a man on to put the Royals ahead by a score of 5-4. Manager Martin objected, claiming that the pine tar on Brett's bat extended beyond the permissible 18 inches from the handle. Plate umpire Tim McClelland conferred with crew chief Joe Brinkman and with umpires Nick Bremagan and Drew Cobble. The portion of the bat covered with pine tar was measured and found to be well over 18 inches. Brett was therefore called out, ending the game and giving New York a 4-3 victory. The umpires cite official playing rule 6.06a, which states that a batter is out for illegal action when he hits an illegally batted ball. They state that rule 1.10b provides that a ball hit with a bat treated with any material, including pine tar, which extends past the 18-inch limitation, shall cause the bat to be removed from the game, and is therefore an illegally batted ball. They ruled that since the bat used by Brett was illegal under Rule 1.10b, and since Rule 6.06a provides that a batter hitting an illegally batted ball is out, Brett must therefore be called out and the home run nullified. Decision. It is the position of this office that the umpire's interpretation, while technically defensible, is not in accord with the intent or spirit of the rules, and that the rules do not provide that a hitter be called out for excessive use of pine tar. The rules provide instead that the bat be removed from the game. The protest of the Kansas City club is therefore upheld and the home run by Brett is permitted to stand. The score of the game becomes 5-4 Kansas City, with Kansas City at bat and 2 out in the top of the 9th inning. The game becomes a suspended game at that point and must be completed before the close of the season if practicable, or at the close of the season if it should affect the first place position in either division. The reasoning of this office in reaching the above decision is as follows. 1. Official playing rule 6.06a states that a batter is out for illegal action when he hits an illegally batted ball. An illegally batted ball is defined in the rules as including one hit with a bat, which does not conform to official playing rule 1.10. 2. Rule 1.10 outlines several requirements affecting the legality of a bat. One of these is that the bat handle, for not more than 18 inches from the end, may be covered or treated with any material, including pine tar, to improve the grip, but that no such material shall improve the reaction or distance factor of the bat. Rule 1.10 specifically provides that if the pine tar extends past the 18-inch limitation, the bat shall be removed from the game. If it was intended that this infraction should fall under the penalty of the batters being declared out, it does not seem logical that the rule should specifically specify that the bat should be removed from the game. *****. 18. 3. It is more logical to infer that the second part of the definition of an illegal batted ball, that pertaining to a bat which does not conform to Rule 1.10, is meant to refer to bats covered under Rule 6.06d, which have been altered or tampered with in such a way to improve the distance factor, or cause an unusual reaction on the baseball. *****. 4. It is the conviction of the league president that the intent of the above rules is to declare a batter out and to inflict discipline upon him for use of an illegal bat, which has been altered or tampered with to improve the distance factor or cause an unusual reaction on the baseball. It has not been seriously contended that the pine tar on Brett's bat did either. It is not the intent of the rules to declare batters out or discipline them for improper use of pine tar. The provision restricting the distance pine tar can extend up the barrel of the bat was primarily intended to keep from spoiling the ball and requiring new balls to be constantly brought into the game. Conversations with several members of the Rules Committee reinforce this belief. The provision to prevent this is specifically spelled out in Rule 1.10, i.e., remove the bat from the game. 5. As stated, it has not been the usual practice in the major leagues to call batters out for using a bat with excessive pine tar. President MacPhail discussed 2 prior incidents concerning excessive pine tar on bats. Conclusions. A protest is allowed based on the league's decision with respect to the proper interpretation of the rules involved. It is the league's position that meaning and intent is to discipline and declare out batters using bats that have been tampered with to increase distance potential, but not to treat pine tar excesses in the same manner. Instead, the use of bats with pine tar extending beyond 18 inches should simply be prohibited. The opposing team has the right to call the infraction to the umpire's attention and ask that the bat be changed or cleaned up. B. Although manager Martin and his staff should be commended for their alertness, it is the strong conviction of the league that games should be won and lost on the playing field, not the technicalities of the rules, and that every reasonable effort consistent with the spirit of the rules should be made to so provide. C. Although the umpires are being overruled, it is not in my opinion the fault of the umpires involved, but rather is the fault of the official playing rules, which in some areas are unclear and unprecise. The rules, which must cover many complicated situations, have been in effect for many years and have been amended repeatedly. At times, however, other rules affecting related situations have not been brought into conformity. The responsibility for this, and the responsibility perhaps for the lack of clear, uniform instructions to the umpires on the interpretation of the rules, must rest with those of us in administrative positions in baseball, including myself. Notes and questions. 1. The official rules of the National Football League provide for an appellate procedure within the game of football, known as instant replay. Under the rules, the referee, after reviewing the videotape of a play, may reverse a call made by a field official. The rules provide. 19. A decision will be reversed only when the referee has indisputable visual evidence available to him that warrants the change. Official Rules of the NFL, Rule 15, 9, 2011. Why should this be the rule? In the case of a close call, why shouldn't the referee exercise his best judgment? The replay rule also provides reviewable plays. The replay system will cover the following play situations only. A. Plays governed by sideline, goal line, end zone, and end line. 1. Scoring plays, including a runner breaking the plane of the goal line. 2. Pass complete /incomplete /intercepted at sideline, goal line, end zone, and end line. 3. Runner /receiver in or out of bounds. 4. Recovery of loose ball in or out of bounds. B. Passing plays. 1. Pass ruled complete /incomplete /intercepted in the field of play. 2. Touching of a forward pass by an ineligible receiver. *****. There are other play situations in the list. ID. Why are only some play situations subject to replay? 2. Did President MacPhail determine that there was an indisputable error in the ruling of the field umpires in the pine tar case? If not, what explains the difference between the football replay rule, in which reversal of the field official's call is possible only in cases of indisputable error, and this decision in a baseball appeal? 3. President MacPhail ordered that the pine tar game be concluded on the 18th of August, 1983. The continuation of the game was almost scuttled by a lawsuit brought by ticket holders who had attended the first part of the game on the 24th of July and who alleged they had a right to see the conclusion. of the game without paying the $2.50 admission charge announced by the Yankees. A New York State trial court enjoined the game from proceeding, but an appellate judge vacated the injunction and ruled, play ball. In the end, the Yankees allowed prior ticket holders in for free. The continuation of the game lasted just 9 minutes, 41 seconds, since all 4 remaining batters, 1 from Kansas City and 3 from New York, made immediate outs. The Yankees therefore lost, 5-4. 20.